All right, council, is there anything that we need to take up before we bring the jurors in?
No, you are.
No, you're not.
All right, very good. Let's bring jurors, please. Welcome back, ladies and gentlemen. Thank you all for arriving promptly so we can get underway. Check to make sure that you have your own notebook there for the state.
Yes, sir. Your Honor, state called Jennifer Remy. I do.
Ms. Franks.
Thank you. Ma'am, would you please state your name and also spell it for the court reporter?
My name is Jennifer Remy, R-E-M-Y.
And how are you employed, ma'am?
I am a forensic scientist with the North Carolina State Crime Lab, where I'm assigned to the trace evidence section.
And how long have you been employed there?
Approximately 13 years.
What kind of work do you do?
I work in the trace evidence section as a hair, fiber, paint, tape, pepper spray, and physical match analyst.
And can you explain what a forensic hair examiner does?
A forensic hair examiner takes evidence collected from a crime scene, so hairs either at the crime scene or from items of evidence collected from the crime scene, and compares them back to known hair standards, which are hairs taken from a particular individual, to determine whether or not these hairs from the crime scene could have come from that particular individual.
And what type of education and training have you had?
I have an honors Bachelor of Science degree in chemistry from the University of Delaware. While I was there, I had an internship with the Delaware State Police Crime Lab. I then went on to the University of Illinois in Chicago, where I received my Master's of Science in Forensic Science degree. While I was there, I had the opportunity to take several different forensic microscopy classes at the Mangum Research Institute, which is one of the world's leading microscopy training centers. I was then hired into the crime laboratory, and I underwent the in-house training programs in hair, fiber, paint, the disciplines that I specifically listed earlier. During that training, and then after the completion of the training, we also take outside classes. I've taken classes at North Carolina State University, at Bowdoin College in Maine, and at the University of Missouri in Rolla. I attend different workshops put on by the Federal Bureau of Investigation, by their crime laboratory. We also attend just different seminars in the areas that we work in different types of instrumentation that we work with. We attend national and regional meetings such as the Southern Association of Forensic Scientists, American Association of Forensic Scientists, and the Trace Evidence Symposium. I'm a member of the Southern Association of Forensic Scientists, the American Society of Trace Evidence Examiners, and I'm a fellow with the American Board of Criminalistics with a specialty in hair and fiber analysis. I'm also an acting member of SWIGMAT, which is the Scientific Working Group for Materials Analysis, which is a group of about 60 national and international experts that meet approximately once a year to set best practices in the different fields of forensic science. Currently, I'm in the fiber subgroup, and I'm the chairman of the fiber subgroup.
Have you ever testified in court before as an expert hair examiner?
Yes, in both state and federal court.
And how many times approximately?
Approximately 30.
Your Honor, at this time, the state would tender this witness as an expert in hair examination and identification.
Any objection?
No, Your Honor.
Her testimony will be received as proffered.
Thank you, Your Honor. Would you explain to the jury exactly what characteristics you're looking for when you examine hair?
When we look at a hair, the first thing we have to actually determine is whether or not what we're looking for is actually a hair, or is it some sort of fiber or vegetable material. Once we determine that it is in fact a hair, the next thing that we're going to look for is what part of the body that it could have come from. As a forensic hair analyst, the only parts of the body that I can do a comparison on are on head hairs and pubic hairs. So if I've determined them to be a head hair or a pubic hair, I then take those hairs from the crime scene and mount them on a microscope slide. So I take a slide, I put some glue on it, I put the hair, and I put a cover slip. And the slide and the cover slip are both glass, so it's kind of like a glass sandwich with the hair in the middle. I then take my known hair standard and mount that on another microscope slide. Once I have those mounted, I take them to a comparison microscope, which is basically two microscopes that sit side by side next to each other. When I look into the top, I can see a split screen with the image from the question hairs on one side of the screen and the image from the known on the other side. So I can do a very detailed side-by-side comparison of the question to the known. When I'm looking at the question hairs and the known hairs under the microscope, one of the first things that we're looking for is, one of the things that we're looking for is I like to explain it as if you think about a pencil. So one of your yellow number 2 pencils, when we can look at hairs under a microscope, it's a good analogy to this number 2 pencil. So just like the number 2 pencil has a thin outer coating of paint on it, so also does a hair have a thin outer coating. It's made of scales, much like the scales of a fish or a snake. These scales can be far apart, they can be close together, they can be pulled away from the hair. It all depends on what your hair, how you take care of it. Just like the pencil has the lead running through the center, the hair can have a central core of cells called the medulla. And the medulla can be present, or it can be absent, or it can be fragmented throughout the length of the hair. Again, it just depends on the individual. Then the woody part of the pencil corresponds to the cortex of the hair. And in the cortex of the hair, we find the pigment. And so the pigment granules can be round, they can be oval, they arrange themselves in a variety of patterns. They can be spread far apart, they can be clumped, they can be kind of streaky in appearance. Just like the wood grain of oak is different than the wood grain of pine, these pigment patterns vary from individual to individual. And then finally, we can think about the eraser of the pencil as the root end of the hair. And the root of the hair goes through 3 main growth phases. It has the anagen growth phase, which is the actively growing phase, at which point the hair is firmly attached to your head. It's not going to fall out on its own. This is where it's actively growing. You have the catagen phase, which is a transition between the actively growing phase and the more dormant phase. And then you have the telogen phase, which is the point at which your hair is no longer actively growing. It's ready to be shed from your head, and if you were to look at your clothing and you find a random hairs attached to your clothing, those are typically going to be your telogen hairs because they fall out naturally. And then when you look at the hair, you have the tip of the hair, which corresponds to the tip of the pencil. So like the tip of your pencil could be worn with use or could be freshly sharpened. The tips of your hair can be abraded, it can be freshly cut, they could be naturally tapered. Again, it all depends on your hair and how you take care of it.
Thank you. Did you have an occasion to examine hairs from a case that occurred April 3rd, 2011 in Durham involving Reginald Day as a victim?
Yes, I did.
And did you examine items in that case?
Yes, I did.
May I approach the witness, Your Honor?
Yes.
Ma'am, I'm showing you what's been marked as State's Exhibit number 45. If you take a moment and see if you can identify that.
I can.
And what is it?
State's Exhibit 45 is my laboratory item number 9, which is hair.
And how did you receive that particular item?
I received this item in the sealed manila envelope.
And what did you do with that item once you received it?
When I received it, the first thing we do in the laboratory when we receive an item of evidence is the evidence all has been applied a barcode, which has the unique case number assigned to this case, as well as the individual item number. We then apply the date and our initials. That way we can identify it in the future.
May I approach the witness again, Your Honor?
Yes.
I now show you what's been marked State's Exhibit number 46. Can you identify that item?
Yes, I can.
And what is that item?
This is my laboratory item number 25, and it's hair from 3507 Century Oaks Apartments.
Now again, how did you receive that particular item?
Again, this was in a sealed manila envelope.
Now, did you do analysis on either of those two items, State's Exhibit 45 and 46?
Yes, I did.
If we can go to your number 9, State's Exhibit 45, what exactly did that contain?
State's Exhibit 45, my item number 9, contained a large clump of hair.
And do you know where that hair was located? Was it indicated?
No, I do not know.
And when you say a large clump, what do you mean by that?
I noted that there were more than 150 hairs present.
And what did you do with that particular item?
With State's Exhibit 45, my item number 9, I took the clump of hair out and I examined it looking to see if there was actually hair present or if it was fibers or if it was something else. And looking under a stereo microscope, which is a low-powered microscope, I noted that there were approximately more than 150 hairs, and I noted that there were approximately 17 hairs that had roots attached to them. So, and they were all in the telogen phase roots, but that the remaining hairs were fragments. I mounted a representative sample of those, so I selected several, placed them on a microscope slide, and then examined them to see actually if they were hairs. Even though they looked like hairs under the stereo microscope, some of them could be fibers. And I examined them using a higher power microscope, and I noted that they were all hairs and there weren't any fibers present in that representative sample. Later on, I went back and actually mounted all of the hairs to see if there were any fibers present, and there were not. They were all hairs present.
So you mounted all 150 hairs?
Yes.
And what type of microscopic characteristics did they have?
I noted that they were all Caucasian head hairs, which means some of the microscopic characteristics that I looked at can help to attribute the hairs into one of 3 main racial categories, either Caucasian, which would be of European ancestry, Negroid, which would be African ancestry, or Mongoloid, which would be Asian or Native American or Eskimo ancestry. And so the sum of the properties, the microscopic and macroscopic properties that I looked at indicated that they were of Caucasian ancestry. And, oh, sorry.
Go ahead.
I also noted that some of these, they were mostly shades of brown. Some black hairs were noted, that they were length up to approximately 6.5 centimeters. Some of the hairs appeared to be dyed.
Okay, and when you said you found 17 that were in the telogen phase, would you explain again what that means to the jury?
Sure, when we're looking at hairs, one of the things that we look at is that the equivalent of the eraser end of the pencil or the root end of the hair, trying to attribute what phase of growth it was in. In this case, that approximately 17 out of those more than 150 hairs had a root present, And those 17 were all telogen roots, which meant they were in the dormant phase. They were not in the actively growing phase. They were ready to be naturally shed. The remaining of the hairs were fragments, which means there was no root present, so they were either broken or cut on both ends.
And those fragments, how long did you say the longest one was?
Up to approximately 6.5 centimeters.
And you said it meant there was no root present, so they were either cut or...
There was no root, so they had to either be cut or somehow broken off. The root part was missing.
Now, when you say broken off, a cut, obviously, you take scissors, you cut hair. When you say broken off, how could that occur with not having a root on it? I don't really have a good explanation as to how it could be broken with 150 hairs, how they could be broken off. Usually, sometimes we see one or two where the hair just breaks and sort of peels apart. There's some sort of damage to the hair which causes it to break instead of actually being pulled out from the root. Now, were you able to draw any type of conclusion as to whether any of these hairs, the fragments or the ones in the telogen phase, could have been pulled out?
Because in order for me to say that a hair was forcibly removed from the head, we have to look at the root growth phase, which is why I noted it here that it was telogen. In order for me to say it was forcibly removed, it would have to be in the anagen phase, which is that actively growing phase. It would have to be in the catagen phase, which is in the transition from the actively growing to the dormant phase. Or if it's in the telogen phase, there would have to be, sometimes when they're in the telogen phase, they can come out and pull a little bit of skin with it. So a little bit of the scalp or the tissue might come with it. In that case, we can also say it was forcibly removed. In this case, I said that the hair was telogen roots with no skin tag on them, which to me indicates that I cannot say that those were not forcibly removed. And then because of the fragments, I also cannot say that I can't make any judgment on the forcibly removed or not forcibly removed. I have to say they're not forcibly removed because there's no root there to examine.
And State's Exhibit number 46, what was that particular item?
State's Exhibit number 46 is my item number 25, which is hair from 3507 Century Oaks Apartments.
And how many hairs, or how many did it appear to be when you opened that package?
It was, again, a large clump of hair with more than 75.
And what did you do with those hairs?
When I was looking at the large clump of hair, I noted that there were two types, a black kind of color and then some shades of brown. When I used that stereo microscope, which was the low-powered microscope, I noted that there were approximately 5 hairs with telogen roots. They were between 9 and 20 centimeters long, and they were all light brown. And then the remaining hairs were fragments. The light brown ones were between 12 and 31 centimeters, and the black ones were 13 to 36 centimeters. And most of the ones that were present were that light brown color. And so I went ahead, just like I did in the other one, and mounted a representative sample to either confirm that they were all hairs or see if some of them were fibers. The microscopy revealed the presence of several fibers. So what I originally thought was more than 75 hairs turned out to be a combination of both hairs and fibers.
Do you know how many were hairs and how many were fibers?
No, I didn't actually count to determine how many were hairs and how many were fibers.
And were you able to make a determination whether this particular sample was forcibly pulled out?
During the stereo microscope exam, there were approximately 5 hairs with telogen roots present. Again, no tags on them, no skin tags on them, so those were not forcibly removed. The remaining were all fragments, so again, not forcibly removed because there were no roots present.
And as far as the fibers, what, if anything, did you note about the fibers?
I made a note that they are long, tan, man-made fibers. I also made note of a couple of the microscopic properties, which included a characteristic that we call fish eyes, which are little triangle-shaped markings on the fiber themselves. They had high white polarization colors, which is just, we use a polarized light microscope, and that's one of the techniques that we use, and one of the properties that I made note of. And then they were also striated, so they had, it looks under a microscope like lines running down the length of the fibers.
Could you tell what they were?
I didn't make any guess as to what they were. High white polarization colors would indicate something along the lines of polyester, perhaps, but I didn't do anything to confirm what it could be, what the actual polymer content of the fibers were.
And did you make a written report as to your findings?
I did.
How many personal witnesses?
Yes, ma'am.
I'll show you what's been marked State's Exhibit number 47. You take a moment so you can identify that item.
Yes, I can.
And what is that item?
This is a copy of the report that I prepared in this case.
And other than the red State's Exhibit sticker, has it been altered in any way?
No, it has not.
Your Honor, at this time, the state moved to enter into evidence State's Exhibit number 47.
Any objection?
No, Your Honor.
It's allowed.
And we'd also ask that it be published, and I have made copies.
Yes, ma'am. You'll hand that to the bailiff.
If I may take that.
Yes.
Further questions at this time, Your Honor?
Cross-examination, Mr. Meyer.
Yes, sir. Good afternoon, Mr. Remy.
Good afternoon.
Now, are you familiar with hair weave?
Yes.
Okay. Can you explain what a hair weave is?
A hair weave is typically something an individual would add to their hair to either make their hair longer or fuller. It's either artificial hair, just not your own personal hair.
Well, it's either artificial, but can it be natural hair?
Yes, in fact, it can be. You can get, there are different kinds that you can get. You can get ones that are completely synthetic, so they would be fibers. You can also get ones that are made from human hair.
And how are weaves attached to, I mean, how do you put them in?
I'm not terribly certain. I've never done one myself. It's my understanding you can glue them in, you can sew them in, but they do attach to the individual's head.
Do you have any way when you look at hairs of knowing if they're part of a weave or not?
No, I don't.
Do you know if someone has a weave and they pull it out, are you likely to find all these roots attached?
When I say something is forcibly removed, it would be forcibly removed from the individual whose head it grew from.
Okay.
So if there was a head, I can say that if I pull my hair out, it was forcibly removed, but if I removed my hair some way and someone else had it as a weave, I would not be able to say if it was forcibly removed from their head.
Okay. So if someone has a weave and someone else is dragging them down the hall by that hair and it breaks off, you would not necessarily be able to say that that hair was forcibly removed.
That's correct.
Okay.
Excuse me.
Nothing further, Your Honor.
Ms. Franks?
Ma'am, when you say you think it's glued or sewn in, would that be to existing hair pieces? I mean, it's not actually glued to their scalp.
No, I don't believe so. I think it's attached to their hair, or they braid their hair and it's attached to those braids in some way.
Now, what is the strength of hair? Do you know that?
I do not have any idea.
Now, as far as all of these fragments, were you able to give an opinion as to whether they appeared to be more cut or broken?
I don't believe I indicated. I did note that several that were cut. And I didn't indicate that any were broken, but I know when I look at them, when I think of fragments, typically, that's not true. No, I have noted that there were several, about a representative sample of hairs with roots and several that were cut. Those would have been some of the fragments. There are ways to determine if they were cut with scissors or cut with a knife, and there's ways to indicate if they were broken. I didn't make any notes about them being broken. It does say cut in my notes. I don't recall exactly what the hairs themselves look like at this time, so I just have to go by with what I said. So.
And in your notes, the ones you did look at were cut.
Yes.
And in your notes, you made no notation that you found any that were broken.
Correct.
No further question, Your Honor.
Mr. Meyer?
Yes. Typically, the hair that would be harvested to be used in a weave, would it be cut from the scalp of the person it was taken from or broken off from their scalp?
It would be my belief that it would be cut, but I don't know.
Okay.
I don't know how they're constructed.
So, again, if someone has a weave, it's pulled off, there would be no root attached necessarily since it wasn't their natural hair. Could you tell if that would have been cut or broken if it was ripped out?
No.
Nothing further, Your Honor.
Anything further, Ms. Franks?
No.
All right, thank you, ma'am. You may step down.
Your Honor, the state would ask that Agent Remy be released.
Ms. Remy, you're released from your subpoena. You're free to go. Thank you. Ms. Franks, further evidence for the state?
Yes, Your Honor. The state would call Stefan Royal. Sir, would you please state your name and then spell it for the court reporter?
If you'll move forward just a bit so you're close to that microphone.
Stefan Royal, STEPHON ROYAL.
How are you employed, Mr. Royal?
I'm a maintenance technician in Amber Oaks. Used to be Country Scene.
What is a maintenance technician?
Oversee maintenance in the complex. All the maintenance.
Can you move that, either move up or move the microphone a little bit closer to your mouth? That way everybody there.
Now, you said you also was the maintenance technician when it was known as Country Scene Apartments.
True.
On April of 2011, were you working as a maintenance technician at Country Scene Apartments?
Yes.
And when you were talking about what you did as a technician, would that include fixing any damage in any apartment?
True.
Did you know the victim, Reginald Day?
Yes.
How did you know him, sir?
I've been knowing Reggie about 30 years more. Grew up with him.
Did he live in Country Scene Apartments at this time?
Yes.
Do you know how long he had lived in those apartments?
Probably about 3 years, close to 3 years, if not 3.
And do you know how he paid his rent?
Money orders.
During the time that he lived there, can you remember any time that you had to go in and fix something that had been damaged?
He had one little incident where he had a spill of grease or something in the apartment. That was about it.
That was all?
I'm sorry, could you have that answer repeated?
Could
He
you?
had a spill in the apartment with some grease. He had started like a grease fire or something that caught on fire.
The jurors are saying they're having trouble
Oh, I'm sorry.
hearing you.
I'm sorry. Yeah.
There we go.
Okay.
If you could say that again, please.
He had a grease fire.
When you went up there to fix it, was it from cooking or something else?
Cooking.
Now, do you know how old these apartments are?
About 25, 28 years, something like that.
And again, just please speak up. Can you describe to the jurors what the bathroom doors look like, what they're made of?
It's more of a like a particle board type thing. It's not a solid door. It's like soft. It's kind of a soft door. It's nothing in between it. Like sorry, excuse me. Got this off. Excuse me. Sorry. Hold on. Okay. It's like it's a hollow door on the inside, basically.
And you said it's soft. What do you mean by that?
It's not a solid door like this table. It's solid. It's between it. It's just a gap. You know what I'm saying? There's no boards or anything, plywood or anything inside.
As your experience for the maintenance technician there, are they easy to break, damage?
Yes.
How easy are they to damage?
Oh, I done repaired quite a few. They're very easy.
Have any of those been damaged by children that you know of?
Probably running toys or something to it. Maybe, something hard, bicycles. Some kids about 10, 12 years old.
And I ask you the same thing about the frames in the bathrooms. Are they also made from lighter materials and not as heavy duty as newer buildings?
They're a little heavier than the doors. Wood.
Now, during the time that you saw Reggie at the apartments, did you ever see him with girlfriends or women?
True.
How did he act most of the times you saw him?
Just normal. I've never seen him fussing and cussing.
Do you know whether or not he drank or anything?
Yes, he drank
Do you know what he drank?
beer,
Do you know what he did for a living?
paint,
And again, please speak up, sir.
paint.
The time that you were maintenance person there and that Reginald Day lived there, do you ever have any occasions to see him in any type of fight, altercation, or anything in his apartment?
Never.
Did you ever see him with the defendant?
Yes.
Do you remember when that was?
I can't put my finger on it right now. I mean, it's like about, I don't even remember how long it's been since it was like 2 years now. Already.
How often did you see the defendant and Reggie together?
No more than about a month or a month and a half.
Did anything about any of the times you saw them together draw your attention or anything?
No.
Thank you, sir. No further questions.
Mr. Meyer?
Okay. Good afternoon, Mr. Roy.
Yes, sir.
You said you knew that Reggie paid his rent via money orders.
Yes.
How did you know how he paid his rent?
Because I'll be in the office when he bring him or when he buy him, I see him, he'll show him to me sometime, you know what I'm saying? He said, I have me to drop him off at the office.
Okay. You also indicated that the doors to the bathroom are kind of soft.
Right.
And they occasionally get broken.
Right.
What kind of breaks did you see in them?
I've seen holes in the doors, the door jam split, all types of things.
Okay. Have you ever had to repair the frames being knocked out from the top?
Yes.
And what about strike plates being knocked off?
Yeah.
Is that easy to do? To knock off, not to repair it, to knock off a strike plate?
Not real easy,
Okay.
but it happens.
So it would take quite an effort to knock a strike plate off the door frame.
It depends on the door frame been damaged before, the strike plate been damaged before. You know, sometimes they just do an easy repair to, you know, fix a door and jam back.
Okay. You said you knew Reggie drank. Did he drink much?
Mostly beer. I mean,
Right, but I mean, when he would drink, would he have one or two, or would he have more?
I've seen him drink 4 or 5. You know, that's
Okay. Nothing further, Your Honor.
Ms. Franks?
Nothing further, Your Honor.
All right, thank you, sir. You may step down.
thank you.
Your Honor, the state would ask that Mr. Warren be released.
Mr. Rowe, you are released from your subpoena. You're free to go.
Thank you.
Further evidence for the state?
Yes, Your Honor, if Mr. Meyer will make part.
Yes. Counsel outside the presence of the jury, so what we'll do is call for an afternoon recess for your benefit and ask you to return to the deliberation room in 15 minutes. We will also take a short break as well, so I don't know if we'll be ready for you in 15 minutes, but I suspect it won't be much longer than that. If you'll recall the instructions during the recess, don't talk among yourselves or with anyone else about this case. Don't form or express any opinions about the outcome. No media or independent investigation regarding these matters, and please have no conversation or communications with parties, witnesses, or lawyers. If you leave your notebooks in your chairs, and again, gather at 25 minutes past 3 in the deliberation room. Outside the presence of the jury, Ms. Franks, you indicated that the next witness you may inquire about evidence that would fall under that potentially could fall under Rule 4 or 4B of the Rules of Evidence. Is that correct?
Yes, sir. It is
All right.
correct.
And could you tell me just very generally the nature of the 4 or 4B evidence that you're offering and for what purpose you would be offering it?
Yes, sir. There's a group of witnesses, the first which would begin with the victim of a previous incident that occurred February 17th, 18th of 2010. And the first witness would be the victim. And it would be a previous incident that involved the defendant and a male victim who she was living with at the time, which the state would argue is the facts are similar and it's close in time. It would be offered for the purposes of motive, opportunity, intent, absence of mistake or accident, plan, knowledge, and preparation. It'd be offered for all of them, basically.
All right. Mr. Meyer?
And Your Honor, we would ultimately object to that. I mean, first of all, I don't know what she means by it would be offered for opportunity. That, I mean, she never stabbed this other man. I understand this is the one, that's the incident that she was charged with, arson and a bunch of other charges, which were ultimately she was not convicted of. She was convicted of some misdemeanors. I think it would be more prejudicial than probative at this point, especially if she's not intending to take a stand. And especially because in that case, and we have not gotten to the point of Mr. Day's testimony, where unless we can show in that case, that he had been holding her against her will, he had been pursuing her into a bathroom, I just think it's more prejudicial than probative at this point to be getting into her interactions with another individual, especially before she testifies and we get into anything related to that here. And as far as, again, motive, opportunity, intent, absence of mistake, there's been no evidence that this was, as of yet, that this was a pre-planned incident with Mr. Day. So trying to bring up that, she's been in abusive relationships before, and when she's in abusive relationships, she's occasionally threatened them. I just think that's more prejudicial than probative at this point.
All right. Ms. Franks, I believe let's talk about proximity and time. The dates you gave me were February 17, 2010 was the prior conduct that you're talking about, is that correct?
The 17th and 18th, it may have gone to the early morning hours of the 18th.
All right, so approximately
Yes.
14 months prior to the incident that's subject of this trial, is that correct?
Yes, sir.
All right, so that's, as far as the temporal proximity, let's talk about what is it about the conduct that you anticipate the testimony showing that would be substantially similar or probative for the purposes that you've discussed, namely motive, opportunity, intent, absence of mistake or accident, plan.
The testimony will show that on that particular date, a male by the name of Milton Walker was living with Miss Mangum and her children. That they had, she had been drinking, not sure about him, but they had gotten into an argument when he got out of the shower. And during that argument, she threatened to take pictures of his penis and started attacking him and trying to get his clothes off of him. He then proceeded to put his hands on her to hold her down. And while he was holding her down, she basically was like, "Get your hands off me," just kind of fighting to get loose. And he was holding her down to keep her off of him. And he told her, "I'll let you go if you calm down. Are you going to calm down?" She said yes. He let her go. When he let her go, she immediately went and got a kitchen chair, started hitting him with the chair, took the chair from her and threw it out of the way. Then she went and got a step ladder and started hitting him with the step ladder. He then took that away from her and threw it away. Then she went into the kitchen and he could hear the clash of silverware and thought she was getting a knife because she made a comment, "I got something for you." And before she could come back out, he ran in ice cold weather because he was scared. One of the children called 911, so 911 responded. At the time the officers responded, when they drove up, they saw Mr. Walker's vehicle severely damaged. A vacuum cleaner had been thrown into the windshield. All four tires appeared to have been slashed, and there was some of his clothing was thrown around. They go up, knock on the door. The defendant comes to the door, tells them there's nothing going on, they don't need to be here, they need to leave, acting very calm. They then go in and try to talk to her, we had someone call, what's happened, anything wrong? While they are talking to her, Mr. Walker at this point, he's only got on a pair of sweats and some shoes, it's ice cold, knocks on the door. One of the officers opens the door, he's shivering and allows him to come in and sit right in the living room while the defendant, Ms. Mangum, is being kept by another officer, so they're separated. The first officer that is with Mr. Walker begins to ask him questions about what happened. And all during this time period, the defendant is walking back and forth between bedroom and bathroom. At the time that Mr. Walker started to tell one of the officers what happened, the defendant comes running down the hall saying, "I'm going to stab you, you motherfucker, I'm going to stab you." Proceeds to lunge over one of the officers to try to get to him. At that point, the officers have to take her down. She fights the officers. They're having all kinds of trouble getting her under control. They finally do get her handcuffed. The minute they get her handcuffed, she just lays flat, not move at all, dead, completely dead weight. At the time she's dead weight, they pick her up to try to take her out. Then they put her down because there's children in the house at this time. One officer leans down to her and says, "Hey, you don't want your children to see this." And in the meantime, he shut the bedroom door to the children so they couldn't see the mom going away in handcuffs. She still wouldn't move, and as that officer stood up, he smelled smoke. And he looked at her and says, "What is that on fire? What is burning?" She kept the dead weight, not speaking. He then goes and looks in the bedroom where she had been. There's nothing there. And then he thinks maybe the kids have knocked over a candle. He opens up their door. Everything's fine, shuts it. Then just out of reflex, opens the bathroom door, and the oxygen just poof, flames are everywhere. He pulls that door back very quickly, then tells the other officers, "Drag the defendant out if you have to. Get someone in here, we got to get these kids out." I also have pictures showing injuries on the victim, Mr. Walker, and pictures of the defendant, and the defendant also gave statements to officers, as well as the victim. It's almost identical in circumstance, Your Honor. The only difference is a fire wasn't started, and Mr. Walker ran before he could be hurt any further.
Mr. Meyer.
And Your Honor, I would still say this is prohibited under 404A1. The evidence is strictly being used to show that, Ms. Mangum is occasionally mean to abusive boyfriends. I will again note this case was tried. This is what she was charged with. This is the arson case and everything else, and the jury hung on the arson, didn't convict on the threatening with the knife, and did other ones. I think this is just a backdoor way of getting her 2010 arson trial, which we've been trying to keep out, in here. And I would still say at this stage in the game, especially before we have evidence that this is what happened, we haven't even heard from Investigator Bond. This is what we're going to tell you happened without actually putting on evidence of what happened in this case. They're putting on some of it, but we're still missing a lot of the story of what happened in this case. So I would still certainly object, but I think at this point, before the case has gotten developed further as well, it's still definitely more prejudicial than probative before we can actually let the jury know this is what happened in this case. This is what Mr. Day says happened, which will come in. This is what the investigators say happened. Oh, and by the way, it's happened before. What we're trying to do now is on a Friday afternoon at 3:30 is inflame them and say she's threatened people before, she lit his clothes on fire, she did all this other stuff. And now you go home and then you hear about what's happening with this. Rather than focusing on this, which is what they're supposed to be focused on, they're going to be focusing on what happened 2 years ago. Before the jury even knows if it's similar and can draw their own conclusions. So I would argue, regardless, under both 403, 404, due process, everything else, that it shouldn't be allowed. But if it is going to be allowed, that it shouldn't be allowed to be the first evidence they hear of anything before it's been established that this is similar to the current incident.
Your Honor, just to clarify, she was not found not guilty of these crimes. The misdemeanor charges of communicating threat and assault were not indicted. What was indicted was an arson and 3 counts of misdemeanor child abuse and resisting officers. And she was found guilty of everything but the arson, which was a hung jury. So there's not a prohibition as far as her being acquitted of these items for it to come in. As far as it coming in today, as the state indicated to the court before trial and also during opening statements, because of the location and being able to get witnesses that are out of place, we're putting things out of order. That is the only reason we were going to start this today. Otherwise, we would wait until the rest of the testimony from FSU and other witnesses involved in this case. And if the court wishes us to wait till then, that's fine, but we wouldn't have any more witnesses to today. But we do argue that it is admissible for the purposes that we're trying to admit it, whether you allow it today or at the end of the regular evidence.
All right. I think that at least portions of it are admissible under Rule 404B, particularly for the purposes. I do find that factually the events or acts that are being sought to be admitted are temporally proximate to the acts that are on trial here, and they're substantially similar in certain respects to the acts that are on trial here, and that therefore they are probative, particularly of motive, intent, and plan. I find that they would be probative of those matters. I believe that perhaps the entire litany that you gave to me, and I appreciate you giving me the entire litany so that I can understand it all in context. For example, I'm not sure that the arson is particularly probative of anything. The fact that a fire was set is not particularly probative of any, or it's not substantially similar to the events here. The altercation, the portion of the altercation you described where there was attempt to restrain Ms. Mangum, there was continued attempts allegedly to attempt to assault the alleged victim in that matter, and then the statements made, particularly after the officers came, regarding the use of a knife and the hearing of silverware clattering, those types of things. Those seem to be substantially similar and therefore probative of the purposes that you would suggest that be offered, proof of motive, intent, and plan. Now, I understand the argument about the sequence of these events. I'm not aware of any requirement that 404B evidence be offered in any particular sequence. There is a potential another use for this evidence, which would be under 404A, which perhaps could be offered by the prosecutor as rebuttal evidence if peaceable character or something like that was put in evidence, and that certainly would require a certain sequencing of the evidence that would be permitted on rebuttal. But in terms of 404B, I'm not aware of any particular sequencing. I also believe, Mr. Meyer, that at least through your opening statement, this is the theory that you're going forward on. The jury understands that. So to some extent, it's in play already. I am not, I don't want to sacrifice, even if it's a slight prejudice, to put it in the order that you're suggesting, Ms. Franks. I don't want to, just for the sake of efficiency or expediency, sacrifice even a slight amount of prejudice in this case. And my sense is that I recognize it will inconvenience some witnesses and inconvenience the jury and perhaps affect our efficiency in this case and maybe even cause us to run longer than we had hoped. I think probably the best course of action, though, is to leave it for another day and allow the evidence to come in the order that Mr. Meyer suggests is appropriate. So I think that would be, unless you have a strong objection, I'll hear from you again. Mr. Meyer, I'll be glad to hear from you again. But I think simply sacrificing expediency, it may be called for in this case.
You know, I don't have an objection. My concern, and the only concern I have, is the victim, Milton Walker, is, I don't know the proper word, he's a little slow, and he's having contact with Ms. Mangum. Ms. Mangum started contacting him again this past month. And so
is he here?
he's even been, someone told him which I've explained to him he's a victim, and explained that to him, but there can be no contact from
I see.
anybody, from Miss Mangum or any of her friends' family.
Well, is he here now?
He is here, but he's hesitant, but he's here.
All right.
Yes, sir.
Well, that would be something that would tip the scale the other way, Mr. Meyer.
Well, Your Honor, I mean, I guess my issue with that would be is certainly we can agree to have no contact with him. Certainly Ms. Mangum can agree to have no contact with him. Prior to this being on trial, they did have a relationship, so they had the contact. If there's others who are going to contact, I mean, all I can do is say the people who purport to be acting in my client's best interest aren't, and they need to stop, but I don't control them. I would still argue with that. I mean, this is a first-degree murder trial, and my concern is, for the sake of another hour and a half on a Friday, I'm still worried about the prejudicial value. This isn't a misdemeanor charge. My client is facing life without parole. She will understand, and we will tell her point blank, no contact with Milton. If he contacts you, don't do it. Anyone you talk to or anyone else, nobody can contact this individual. But I would still, this is a serious charge. This is a serious matter. If the state is worried about Mr. Milton's whereabouts, I mean, if he's really that material, they have mechanisms they can use to control it. I am still concerned with the contact, and if we're certainly going to go based on uncorroborated contact, I would at least ask, if you're still inclined to do it today, to go through voir dire and see if Ms. Mangum is in fact doing what the state occurs. I still just think the risk of prejudice in a first-degree murder case should outweigh the little bit of experience of losing an hour and a half on Friday afternoon when we've already been short and, we're actually moving faster than any of us thought. And so it's not like we're suddenly delaying this case well beyond what any of us expected. I think most of us are kind of surprised that we're already this far into this case as opposed to still in jury selection. And so I still just worry about even a slight bit of prejudice when my client is facing life without the possibility of parole.
We're going to move forward. This is not just a matter of expedience at this point. Rule 404B is a rule of inclusion, not a rule of exclusion. The state is entitled to move forward with its evidence. And the ordering of it is not for the court to decide, and it's for the state to decide. If they're prepared to move forward with it today, we're going to allow that to happen if the witnesses are present and available. All right. We're going to take a 10-minute recess. We'll resume at 20 minutes till 4.
Let's reach the 10 minutes.